Good morning, everyone. Welcome to LegalVision's webinar on how to prevent and manage commercial contract disputes. My name's Jodie Thomson. I'm a practice leader in the disputes team at LegalVision.
And my name's Simon Hillier. I'm a lawyer also in the disputes team at LegalVision. Alrighty. Yeah, so just a bit of housekeeping before we jump into it. No need to take abundant notes today because we'll send you a copy of the webinar afterwards. We'll have a little session of questions at the end, so feel free to pop in your questions as we go. And we'll also send a survey around afterwards, and we'd be very appreciative if you could fill it out.
So what we're talking about today is what a lot of our work entails at LegalVision. It's helping businesses deal with commercial disputes, all sorts of commercial disputes, but we're also giving some tips on how to prevent and avoid those from happening in the first place. The content of today is going to include looking at some common causes of commercial disputes, the very first steps to take if things go wrong, how to resolve your dispute without going to court, an idea of what happens if you do go to court. We're going to finish up with some tips then for how to prevent disputes from happening in the first place. We'll have some question and answers where we can answer your questions that you can pop in as we go, and we'll finish off giving you a bit of information about a pro membership that we offer at LegalVision.
Awesome. So to get started, what we mean when we talk about contractual disputes, at their simplest, we're talking about two businesses or two commercial entities reaching an agreement about the provision of goods or services, and there's usually an exchange of money involved. So while contract disputes, come in all shapes and sizes, really we're just talking about when something goes wrong to do with the provision of goods and services, and someone's arguing that someone else owes them money. So we've got a few just kind of categories, examples of the different types of contract disputes we deal with day to day at LegalVision. Common ones are people arguing that someone's breached a contract, breached a clause, trying to get out of a contract. This can be a bit volatile because you don't always necessarily automatically have the right to terminate a contract just because someone's done something wrong. So often this can lead to legal arguments. Another one that's topical at the moment and has been for the last few years is issues around what's called force majeure and contracts being frustrated, things not going to plan because of disruptions relating to COVID-19, for example. So that often adds some complicating factors to contractual disputes. Another example is what's known as unfair contract terms. There are additional statutory obligations, consumer law obligations to in most cases with small business contracts to make sure that your terms are fair. So sometimes it won't so much be a debate over someone's done something wrong, it will be a debate over whether a particular term was even sort of fair and reasonable in the first place. And a final example is what we can call unclear agreements. This is things that aren't documented well, things that aren't written down, paperwork that isn't signed. Contracts aren't always, a contract can be formed verbally or doesn't have to be in a signed document, but often there's debates over interpretation when you don't have clear documentation. So those are just some examples, just contextualize what we're talking about today. So yeah, we'll jump right into it.
Look, the first step we want to focus on is giving some really practical tips about what you do if things start to go wrong. People often feel at a real loss to know exactly what steps they should take. Do they need to go to court? Do they need to ring a lawyer? There's a lot you can do before you see a lawyer, and certainly we'll consider here when it's appropriate to get legal advice. But really there's a lot you can do to work out what's going on and be quite methodical and practical about how to deal with a dispute. Look, a dispute can be anything from all of the type of reasons Simon's mentioned. But from an early point, you'll get an inkling that something's wrong. It might be an aggressive letter from the other party, or it might be somebody owing you money. The first thing to do is to keep the paths of communication open. It's when the relationship breaks down that commercial disputes are very difficult to resolve. So we recommend from the very beginning having a mindset of being prepared to communicate and negotiate. People who do that, parties who do that, are far more likely to resolve their dispute with a minimum of cost and stress, and certainly avoid court action. And that's a mindset that we urge from the start.
And something to always do when you sort of realize that you might be in a dispute is start taking notes. Put everything in writing. If you have an argument with someone on the phone, take a note afterwards, what was said. Meetings, keep a file note. This is really useful because if you can't resolve it quickly and you do have to get lawyers involved, often there's a bit of a exercise of going back and reading everything that's happened, everything that's been said to help figure out the legal position and options and strategies. And it's significantly easy to figure out a path forward when there's clarity amongst what's being alleged by one party to the other.
The other thing we recommend, and this seems obvious, but it's something that a lot of parties don't really do at the outset, is be familiar with your contracts. Nobody is necessarily going to read and understand every single line of a business contract at the time that they sign it, but certainly if there's a dispute, it's really important that you are familiar with it, that you've read it, that you can even find it, in the company filing system. That's often an issue we have. And then go through it really carefully and look for the provisions that might be relevant to the dispute. For example, it might be your lease. It might be a lease dispute over who's responsible for the air conditioning, or when a rent review has to take place. In particular, we recommend looking out in your contract for whether or not there's a section that will tell you how to deal with a dispute. Many commercial contracts actually have a step-by-step procedure for parties to follow if there's a disagreement about something. And for example, it's there essentially to help parties work out an answer, but really to stop an aggrieved party from running off to court. They often might direct parties to put things in writing first, to include some notice periods, perhaps to attend mediation. And parties are bound by the terms of obviously their initial contract, but also the terms of whatever that dispute resolution procedure is. So that's a really useful starting point if it's in a contract that you've got to work out what your options are to deal with it if you still can't reach an agreement before anybody runs off to court.
Yeah, and another reason why it's useful to check the dispute resolution provisions or sort of breach provisions is going back to what I mentioned before. It's possible to incorrectly terminate a contract. So you don't want to jump the gun and just terminate something because you think the other side's in the wrong. You want to check, do I have an obligation to first inform them that I think they've done something wrong and give them an opportunity to rectify it? Because very often those types of provisions are baked into a contract, which is useful ultimately. It serves a purpose of providing a bit of structure to whittling down what can often begin as a bit of sort of an emotive or confusing or complex issue into some quite clear issues that can then be sort of processed. And that's the next point we'll speak to is this is what lawyers do, and this is what you should think about doing as well, is always try and narrow the issues. What's actually in dispute? Like be very precise. If there's a sum of money, what's the sum of money? If there's a period of time that someone hasn't been performing, what's the period? Just try and sort of make it quite, distill it down to something that can be articulated cohesively, I suppose, rather than just having a big long list of grievances. Try and figure out, well, what have they actually done that I think is unlawful in this situation?
And part of that is what we urge, which is keeping an open mind about resolving the dispute. It's not necessary to get on a war footing. It's more productive to be on a dispute resolution position. And that might mean, for example, letting some things go that you might have a grievance with. Again, to use a lease example, you might be a landlord and the tenant might have, there might be a number of small breaches, but really the one that is the biggest concern might be that they owe rent. It's much more effective to focus on that. The other thing we would recommend is looking around, and this can be before or at the same time as you get legal advice if that's appropriate, which we'll talk to next. But depending on the industry that your business is in, there are often organisations, industry or government bodies that can assist parties with disputes. For example, the Small Business Commission in each state, fair trading departments. If you're in a franchise business, there's a franchising mediation advisor, and there are other industry-specific bodies. We use them a lot as lawyers. Often these type of services often have mediation services, which are really useful, but they're a really rich source of information, and they can give you a lot of guidance just to get a handle on what your legal rights might be. They won't necessarily review long contracts for you, but they can help give you a framework of where to go, and in many cases offer an informal dispute mediation service, which can be really effective. They have a very high success rate of resolving things if it's the case that you can do that without needing to get legal advice again or before you need to run to court.
Yeah, and often the kind of driving factor here is, and we'll talk to this more later, there's certainly costs involved with going to court. So these other dispute resolution bodies are often significantly more cost effective in terms of just what you need to pay to get through them, which is why they're appealing, especially in the context of small business, medium business, startups, where the costs of court can be quite just prohibitive by nature. It's worth exploring alternative options. And yeah, the final sort of first thing to do if you find yourself in a dispute is seek legal advice. And what that means is you'll ask a lawyer to look at the contract, to look at the correspondence, and to form an opinion essentially about what your legal position is. Is there a breach? If so, what should you do about it? Or has the other side breached, and how should you respond? They can talk through options, they can talk through strategy, and they can help you weigh up the commercial element of a dispute as well. Like if you were to take this through the court system, here's potentially what you'd be looking at in terms of costs. Let's sort of work back from there. Are there any preliminary steps we can take? Would it be more sensible to try and negotiate a compromise quickly? That type of thing. So always worth getting legal advice if you're feeling a bit out of your depth. And often a little bit of advice right at the beginning can be enough to set a business on the right course to resolve something themselves.
I would just add, Simon, that we often see clients who don't get legal advice at the start of a dispute and end up in strife in some way because they have made a misstep or misunderstood something that's in their contract. Perhaps they've terminated without the proper legal steps and then left themselves exposed to damages just as a result of trying to deal with it. Or we see things go wrong. So sometimes it can be just, as Simon said, worth that initial advice just to make sure that you don't increase your risks, which can happen very easily in contract disputes, particularly if the other side might have you might be trying to resolve it yourself and they might have a lawyer engaged, and a lawyer will very quickly jump on any misstep that a party might make, and you can go from having a strong legal position to suddenly be on the defensive and having to fight quite a different battle.
And another advantage of getting a lawyer to provide advice is they just look at it like an abstract problem almost to be solved, because it's not their dispute, and it can help remove the emotional component from a dispute, which is helpful. Like I think about, I'm a dispute lawyer, but if I was, God forbid, ever involved in a dispute myself, I would want to get a lawyer because I wouldn't want to have to be the one just, entirely driving the matter when I'm entangled in it emotionally. I just think it's quite good to have that someone who's a bit arm's length from the relationships to sort of see through the chaos and be like, well, here's really what this is about. Here's the risk here. Here's the dollars and cents that are at stake, and what are we going to do about it? Cool. So next slide, I think, which is what you can do to try and resolve a dispute without going to court. We will speak about court a bit later on, but the reason why we're framing it like this is as I touched on before, court is just so prohibitively expensive in the context of small and medium business disputes. Can't emphasize that enough. It seems to be the way the world is. And it's unfortunate, but what that means is there's very much almost a mutual interest from a commercial point of view for two parties in a dispute to try and resolve it. And there are some sort of mechanisms in place to do this. One of them is the letter. Send not just an email, but a letter, a formal letter, a legal letter, company letter, something that just really clearly articulates the facts. Here's our relationship, here's the contract. What you're claiming has gone wrong, here's the breach, and what kind of resolution you're looking for. Here's how we propose you rectify it. That sort of ties into the whole narrowing of the issues idea that we talked about before. It adds some urgency, it kind of escalates it by making it a bit more formal. It's, usually in a legal letter we'll say, please respond within 5 or 10 business days, otherwise, we might take this further to court, for example. So it kind of gets things on track to a potential resolution by making it really clear what your position and your argument is. And in a sense, it forms a bit of a foundation for, if it does go to court later, letters, will sort of foreshadow what you'd argue, and they can even be admitted into a court dispute as evidence later on. So yeah, get your letter writing pens ready. You're going to have to be sending a few of these if you want to resolve a business dispute.
Certainly, once we get engaged, it's nearly always the first step that we do in work. There are two types of letters that we use, and sometimes parties acting for themselves can do this as well. One is we call it an open letter that Simon was talking about, and that's the sort that can be used in court, and it's really setting out your legal position. And it's one that can be used as evidence in court. And it's also an exchange of information. That's how we often look at it. So a client will come to us and say, this is my position, the other side's done this and that, and I want to claim this. And we will set out that legal position as persuasively as we can in a letter. And sometimes there's a threat to go to court, and it's not an empty threat. It's quite appropriate to say that if this isn't resolved, our client's position will be that they will go to court. But the other part of the correspondence that's really important, particularly when we're looking at trying to resolve a dispute without going to court, is without prejudice correspondence. And what we mean by that is correspondence where parties are trying to settle or resolve a matter. Any correspondence that is marked without prejudice means that it can't be used in any court proceedings. So it's quite a safe space. For example, if you had a straightforward debt recovery, one party owed the other one $100,000, and you might agree to compromise on a lesser amount. In putting that in without prejudice correspondence, you're not giving up on the full claim if for some reason it didn't end up settling. It just allows parties to have a safe way to settle matters. So very often when we're engaged, we use both of those letters quite strategically. So the open letter, is often aimed to be the scary letter that sets out your legal position and shows the other side that you have a strong legal position, and if you went to court, this is what your claim would look like. But then you come in with a softer, more conciliatory settlement offer in without prejudice correspondence. And often to resolve a dispute, there might be a number of letters going each way between the parties before they finally agree on an outcome.
Yeah, and I mean, this can be before court, it can be during court as well. There's almost just a constant presence of negotiation that goes on through any dispute. I mean, there's sort of the end end of the court process if it ever went that far is someone else making a determination, whereas a negotiation is, you know, you coming to an agreement to compromise in one way or another, and move on. And I mean, negotiation can take all shapes and sizes. It can be letters sending back and forth, or you could agree once everyone's kind of tabled their views to meet and, you know, have a conference to talk it through and see if you can hammer together a compromise deal to allow you all to move on. We've referred to mediation a few times. Mediation really is just a form of negotiation where you have an independent third party who's impartial sort of host a negotiation. And usually this will be a half day or a full day session. They'll just add a lot of structure to it. They'll go back and forth between the parties. The mediator will give everyone an opportunity to say their piece, provide suggestions, encourage the parties to work towards a resolution. It's very different from court in the sense that the mediator doesn't make any decisions and doesn't have any power to bind you to anything, but is there to facilitate the parties reaching a resolution. And one way I've sort of, I always like to recommend mediation, and one way I like to sort of highlight how effective it can be is in my experience, you can often achieve in one day at mediation what otherwise might take 6 months to achieve sending letters back and forth. Because if you're sending letters back and forth, it's very sort of getting into the detail and arguing and nitpicking over things, whereas sometimes in the room it just gives more fluidity to what can be raised and solutions that can be thrown around. And yeah, you can just sort of move forward and tick items off when you're all, you know, met together in an environment where someone's providing you with some impartial guidance. And just to link it back to the whole idea of without prejudice, a mediation will always be without prejudice to the actual dispute. So it's like if you reach an agreement that day and you sort of sign a deal to move on, that's that. But if you don't, then you basically push that all aside and the dispute continues.
And as Simon said, you know, mediation is not about one party winning or losing. It's usually, we refer to it as a successful mediation is if the parties reached an agreement. That necessarily, in most cases, involves a compromise. A successful mediation means both parties have compromised to some extent. You know, in your heart, you might feel that you've won or lost, but that's the way it works. And the other thing, just briefly at the end of this section, when parties do reach a resolution or a settlement, whether it's in a mediation or after a round of letters, in almost every case, the terms of that agreement is set out in a deed of settlement and release. And it's a really important document because it gives you protection, gives both parties a protection that the legally binding document that whatever payments, whatever obligations are agreed, both parties have to stick to, and if they don't, then the other party will be entitled to sue them on that deed. And it also usually includes a release where both parties say, this is it, this is the end of this dispute, and we agree not to go to court over this again.
And the reason it's a deed, which is just a different type of legal instrument to a contract, is sort of not worth worrying about. It's just, you know, a settlement deed is the typical legal document that's used to, you know, wrap up a dispute, come to a deal, make it really clear what's been resolved and who can't sue who and what you can't sue each other about in the future. So, you know, this is, we've been ideally angling to not have to go to court, but sometimes it is an inevitability. You know, sometimes you may have no other options in terms of agitating your claim if the other side's just got their head in the sand, or someone might sue you and that's not something that you're in control of. What actually happens if you go to court? We'll keep this relatively brief just because we could do a whole nother webinar about this topic, and I believe we will in the near future. But what litigation is it's a process. This process can take usually at a minimum 3 months, can take a year, it can take longer, where the parties meet in front of a registrar or a judge a few times, working through all of the admin to do with a case, narrowing issues down, getting evidence ready, making it really clear what the arguments are, what the claims are, putting everything on the table so there's no secrets, and then eventually getting things set up for a trial where witnesses will be examined, barristers will make the verbal arguments, and ultimately a judge will make a decision about who's right or wrong. It's very zero sum. You don't get any of the sort of creative compromises you might get with a negotiation or a mediation with a court determination in most cases. Although it is worth noting that a court will encourage you to settle usually, and often they'll even order you to attend a mediation before they'll have a trial, because the court's always interested in sort of promoting quick, efficient resolutions. This all sounds very exciting. In reality, it's very grueling, and most matters, a number I've heard is 90% of matters that are in court do resolve before going to trial. And the reason is what we were talking about before. Court's expensive. There's no way around that. The reason it's expensive is because it's complicated. You need specialists to help you navigate it. It's a process that no single person's in control of. It's like a tug of war between you, the other side, and the court. Costs just go up, up, up because there's always curveballs. And as a result, there's just always a commercial imperative for businesses, certainly small, medium businesses, to try and settle quickly. So often what we see is a case going halfway through, getting to a certain point, and then eventually the parties just kind of bite the bullet and cut a deal. So that's how we see it. And this viewpoint is very much flavored by the fact that LegalVision works with a whole bunch of small, medium businesses and startups. There is the kind of bigger end of town where big businesses go to war for years at a time over really, really, really big disputes, and have armies of lawyers reading through, basements full of documents. But yeah, what we're talking about today is slightly smaller scale than that. And the reality is it's just a pretty unfriendly system for everyone involved. And as a result, most of the cases we work on typically are resolved by negotiation. Oh, and to throw a number in there, let's just say like a typical court case contested could cost 100K or more. And, we've seen cases where the dispute's over 100K and the fees come to 120K and it settles on the morning of trial and everyone loses basically. Also, if you lose in court, you're likely to have to pay a chunk of the other side's legal fees, so the stakes are very high. And even if you've got a good case, there's always uncertainty. So there's just a whole bunch of reasons why court is not an ideal process for many, many disputes in terms of a sort of pathway to a resolution.
Finally, just to give a few tips for preventing disputes. Most of these are things that we have touched on during the seminar, but just a few reminders. Regularly review your business documents and agreements. Don't put them away in a filing cabinet or a computer system somewhere. Be familiar with them because it will make it a lot easier to know what your rights are and the obligations of your side and the other side in any business dealing. I'll quickly
jump on that point. With once you get to a certain scale, it's sensible to have some kind of contract management system if you're entering into like dozens of contracts a year that have got different terms, just so you're getting automated notifications when things are set to expire and that type of thing. You can just get ahead of disputes by being on top of your documents like that.
Exactly. And also, before you sign a new contract, get some legal advice. In most cases, it will be well worth the investment. It's a relatively small and easy task for a lawyer to review a contract. And we see, I would say, half of the commercial disputes that come to us have dreadfully drafted contracts that we would have been able to change things if we'd seen it earlier on. So it's really quite an important investment given the cost that can happen later on.
And especially in sort of, I don't know, specialist areas, for example, we see a lot of disputes over like software as a service or people hiring IT consultants and really technical specialist things. And you'll have a contract which just doesn't capture the shape of an agreed scope of work or something like that. And there are ways to document this type of thing effectively. And so having lawyers as well who are experienced in the particular sort of service model that you're looking to document is a great advantage in terms of you know, signing up to a deal that you want to be comfortable protects you from a dispute escalating.
And we would certainly say act quickly when disputes arise. And as a last point, this is something that I know we've touched on, but keep your ego and emotions in check. It's really important. It's easy to say, obviously we're all human, but it's very difficult to resolve a dispute when emotions are running high. People don't tend to see things rationally and certainly don't consider the commercial, practical side of things. And by that same token, sometimes it's best to avoid a dispute altogether if it's going to require a lot of legal costs. And that the cost of a dispute can be the cost of your time and stress away from running your business. Sometimes it just might be better to let something go or to compromise from the start rather than to go in fighting. And often that's what happens in the process that we see of parties resolving a dispute.
And there's no one size fits all for this type of thing as well, which goes back, I suppose, to the advice thing. There's often quite a few variables, but it comes down to usually how much money's at stake. Like if you've got an argument, how kind of strong that argument is, or whether there's like a whole bunch of, questionable interpretation issues. Just weighing all of those up can help you decide, is it worth throwing money after pursuing this, or sort of digging my heels in to sort of defend this, or is it worth coming to sort of a quick solution, even if it does feel like I'm taking it on the chin a bit. So yeah, there's no way to escape disputes from happening, especially as your business grows. It's just an inevitability that they'll pop up. So when they do, treat them as a learning experience, and yeah, just be willing to be open-minded about resolutions and to kind of think about these things in sort of very commercial terms in terms of cost benefit.
So that's the end of the content in our seminar. We are going to take some questions, but just before we do, we've put all of this in a very detailed guide, which covers all the different things we've been talking about today, and you can download that in the handout section in the webinar panel and get some more information and detail. But on to the questions.
Yeah, so first one I've got here, how do I make an amendment to an existing signed contract? Which is a good question because so often this is how disputes can come about. Basically, you can come to a new agreement which overrides the old agreement, but it is very much best, it's always the gold standard to do it in writing. And ideally, you could have another contract or a variation of contract drawn up by a lawyer to amend it. The point here, though, is it just has to be by consent. You can't, no one party can change a contract. The whole point of a contract is to basically lock two or more parties into something so that there's certainty for both sides. So you've got to put your negotiating hat on. And if something's not that well documented in the first place, and it might be sort of sensible to update the agreement, put your negotiating hat on and you might be able to sort of, again, get in front of a dispute. It's one of these things where often the resolution to a dispute, a settlement deed, is ultimately the same thing in principle, which is, okay, let's come up with a new deal which overrides the old deal. That's just kind of at the tail end of it being, antagonistic. Amending a contract is just perhaps at the front end of it. You've got to get the other side on board. It's a question of negotiation, presenting your case, whether from sort of a commercial point of view or a dispute point of view if it's a bit more antagonistic.
Here's another question. What can be done if the other party is not responding to your attempt to make contact regarding a dispute? Look, this is probably one of the main things we deal with certainly when we're first engaged. And it's really difficult. And it's part of the strategy that really evolves each step of the way. Every dispute is different, and we often say to clients that whether or not the other side is responding can inform what your options are. If it's the case that you've made some attempts to communicate with them yourself and you've not got anywhere, sometimes that's a good indication to engage a lawyer, because in many cases, receiving a scary letter on legal solicitor's letterhead makes people listen and take action. Sometimes it makes them then go to their solicitor and you've got a full-blown dispute. If after a solicitor's letter you still don't get any response, and we often see that, then we come back to the drawing board, and in some of those cases your only option might be to issue court proceedings. But then there are different things you can do. Sometimes, for example, we might, if a client's got a claim against another one, you've tried to communicate with them, you've got radio silence, rather than jump into court proceedings entirely, we might draft a statement of claim as an initial court document setting out the legal claim, but we don't file it in court, so you don't have the filing fee and you're not actually kicking off the legal proceedings formally. But you then might attach that to another letter, and that can be, we've had a number of matters resolve after that because the other side really sees that you mean business. So, and also you can actually start legal proceedings properly and then resolve it, which is what happens in many cases. So it's really just treading down that path, using the levers that you can pull and seeing what kind of reaction. Sometimes just picking up the phone can actually make a difference or get a response if you're not getting anything back from the other side.
And I mean, we've been sort of taking quite a cautious posture in all of this just because of the context of small business, medium business. But sometimes, I mean, it's always context dependent, and sometimes the best strategy may be just to sue, right? Like really quickly, send a letter. If they don't respond, sue. If it's something that's quite clear cut, if it's just unpaid invoices owing under a contract, sort of a straightforward debt recovery claim, you know, it may just well, like the best way to ratchet up the pressure in terms of cost benefit is just to sue. But if it's more contentious, then there's probably more, you'd probably want to put a bit more thought into the like potential risks of proceeding to court, and like make sure you're comfortable with the range of outcomes and the costs that would be associated with going to court. Because there is a kind of a category which is like the most frustrating to deal with for clients and for ourselves, which is one party just being obstinate, putting their head in the sand. They've done something wrong, but they're just not playing ball. And the reality is the costs of litigating may be too high to worth running the risk. In which case, ultimately, the position may be, well, you may just have to write this off as a bad debt. So, unfortunately, there's no sort of foolproof answer. But certainly, yeah, there's ways of ratcheting up the pressure if you're kind of willing to ultimately follow through with your threats, I suppose, and go to court.
Here's a good question. What are your options if you are dissatisfied with your legal representation, pre-court and at trial? Of course, this is something that comes up a lot, particularly in legal proceedings that are going on for a long time. You know, a client might feel that their lawyer, you know, it's taking too long, that they aren't getting the results that they would want. Maybe it's also costing too much, personality conflicts and all of those type of things. At any point, you can change solicitors. The biggest downside to it, depending on how far along you are, is that there'll be an extra cost of doing so. So at any point, if you're not in an exclusivity arrangement with your lawyer, but if you have a lawyer and you're not happy with them, you can make inquiries of new lawyers. And if you find somebody else that you like, you can engage with them, and then the lawyers will arrange between them for the file to be handed over. But the extra cost that you'll face is that your new lawyer you'll have to pay double for your new lawyer to get up to speed with everything that's gone on. And in some cases, that in itself can be some thousands of dollars just to read in and be able to step in and help. But look, absolutely, if there's a problem of some sort with the lawyer that you've got, you might feel it's the right thing to do. And it can get tricky as well if you've got, perhaps you like the lawyer, but you don't quite like the barrister that you've engaged. And that's something you could perhaps talk to your lawyer about. And we certainly see a lot of matters where lawyers change. We might take over a matter from another lawyer for some reason, or the barrister changes, but the lawyer stays the same. So you certainly do have options there. It's just that it's going to cost you to do so.
Yeah. Another question that's popped up is, can we talk about the standard indemnities that we might see in a contract and how these interact with the dispute? I mean, an indemnity ultimately is a term in a contract which is agreeing to indemnify someone, which is hold them harmless or sort of cover the entire costs of something occurring. So often you'll see something along the lines of, you know, if you get sued for X, we will indemnify you and cover you the costs. Like if you get sued as a result of us doing something wrong, us dropping the ball, you'll indemnify us, in which case you can basically make a cross claim against us and bring us in to cover the costs. And there's certainly a clause that's ripe for argumentation because they're high stakes. Because basically you're just trying to pass on the cost associated with a claim to someone else. I mean, I'm just trying to think of what else to say. They do hold up in practice. Like quite often a dispute will very much turn on whether or not there's an indemnity. But that's going back to our point about it's important to know what you're signing up to, because quite often you'll have a contract that's pretty one-sided, where just one party requires the other party to indemnify them for a whole bunch of things. And if you're seeing these words and you don't quite understand what they're saying in a contract, it's 100% worth getting a lawyer to look over it before you sign.
And I think what I would add, Simon, is that this is something that I think is difficult for people to understand if they suddenly end up in the midst of a legal claim, especially if you're being sued, so you haven't instigated things at all. But any indemnity or limitation of liability clause in that sense, it's not a guaranteed. There's not a guarantee that you will readily get that money back if there are costs that you've incurred and you're entitled to under the contract. Unfortunately, if it is part of a broader dispute, depends very much on the circumstances and the facts of the dispute. So we're talking at quite a hypothetical high level, but often the indemnity itself can form part of the arguments that come up. And you've got to go through that court process to get an agreement and to get a judgment from the court that you're entitled to those costs. So it's not always easy to do it. It really forms part of the broader dispute.
Alrighty, I think that's all the questions that we've got. So I guess to finish off, we can spruik the LVConnect Pro membership, which is LegalVision's offering for SMEs and startups. What it is an all-inclusive membership. What we call business as usual work is all covered under a weekly fee. Probably the area that we do the most of is contract work. We've got a dedicated contract team who can review, they can draft, they can help negotiate, etc. contracts. And rather than sort of billing on a per contract basis or on a hourly rate basis, that's just all covered under the membership. This is for Australia and New Zealand. And then there's a bunch of other categories that we cover as well: business structuring, company setup, trademark applications, employment law, leasing law. The idea being that your day-to-day stuff that comes up that have legal elements involved, you can just kind of book in a call, chat to a lawyer within 2 hours, have a consultation, get documents drafted, etc. In terms of how disputes fits into all of that, a lot of the work that I do is sort of I talk about kind of the early resolution of disputes or kind of jumping on things early. What I find is quite often we'll have clients come to us and it's almost pre-dispute, and we have a chat and I'll talk through, well, here's what I think about your legal position, here's what the kind of cost would be and the process would be if you did need to take this through a court or a tribunal, here's what I think you should do. Full litigation representation isn't included in the membership, I'll be clear about that, which is one of the reasons why we sort of generally encourage people to avoid that. So day-to-day work, is all covered. Dispute work, you know, we're always trying to get ahead of it. Depending on the membership tier you're on, you do get some more involved dispute coverage. But yeah, I mean, that's our membership offering. We can, if you're interested in it, we can arrange a consultation with one of our team. And if you sign up, you've got a 30-day cooling off period as well. So it's something you can give a try. And if you're happy with having lawyers on demand, then you know, it might be for you. So if you want to book a strategy session, we'll send an email around afterwards with a survey, and you can leave your contact information.
Thanks, everybody. That brings to an end our webinar on preventing and managing commercial contract disputes. I hope the information has been really helpful, and I hope that, yes, you are able to avoid disputes and not need any further assistance in relation to them. I hope it's really helpful to your business.
Thanks, everyone.